Welcome to this podcast exploring the Solicitors Regulation Authority, SRA Code of Conduct for Solicitors. This code outlines the standards of professionalism and ethical practice expected from individuals authorized by the SRA to provide legal services in England and Wales. Whether you're preparing for the Solicitors Qualifying Examination, SQE, or seeking to enhance your understanding of legal practice, this episode will guide you through each critical element of the code. This podcast was produced by Dr. Yanis Glinavos and is read out by AI Voices. If you would like to know more about how the podcast was produced, get in touch with Dr. Yanis. Let's dive in. The purpose of the code. The SRA Code of Conduct serves as a framework for ethical and competent practice. It applies to all legal practitioners, regardless of their role or the type of organization they work in. This code covers conduct related to legal practice, even outside the workplace, if the behavior in question has a demonstrable relevance to the profession. By setting these standards, the code ensures that the legal profession upholds public trust and maintains its integrity. It also supports the SRA's enforcement strategy, which details how the authority addresses serious breaches and protects the public interest. Maintaining trust and acting fairly. At the heart of the legal profession lies the principle of trust. Solicitors are expected to act fairly and uphold that trust in all their professional dealings. This means avoiding discrimination and ensuring that personal views do not interfere with professional relationships or the services provided. Solicitors must never abuse their position to exploit clients or others. When they make commitments, they are expected to fulfill them promptly, adhering to agreed timelines, or in their absence, reasonable ones. Misleading behavior, whether intentional or through omission, is strictly prohibited. Furthermore, respect for colleagues is vital. Solicitors must ensure they avoid bullying, harassment, or unfair discrimination. Managers, in particular, have an obligation to address and challenge unacceptable behavior within their teams. Dispute resolution and proceedings. When it comes to legal proceedings, integrity is paramount. Solicitors must handle evidence with care, ensuring that it is not tampered with or misused in any way. Generating false evidence or attempting to influence witnesses improperly is unacceptable. Assertions made in court or during legal proceedings must be properly arguable and grounded in law. Compliance with court orders is a fundamental duty, as is respecting the authority of the judicial process. Solicitors are also expected to contribute to the efficiency of legal proceedings by avoiding actions that waste the court's time. When aware of legal precedents, statutes, or procedural irregularities that could materially affect a case, they are required to bring these to the court's attention. Service and competence. Providing competent and timely service is a cornerstone of legal practice. Solicitors must act only on clear instructions from clients or their authorized representatives. If there is any doubt about whether instructions align with a client's wishes, solicitors must seek clarification before proceeding. Services should always be delivered with competence and tailored to the specific needs and circumstances of the client. To ensure this, solicitors must commit to ongoing professional development, keeping their knowledge and skills up to date. Those in managerial roles also have a duty to supervise their teams effectively, ensuring that individuals providing legal services are competent and well-informed about their ethical and regulatory responsibilities. Client money and assets. The management of client money and assets is an area of practice governed by strict rules. Solicitors are required to account transparently for any financial benefits derived from client instructions unless the client has agreed otherwise. Safeguarding client money and assets is an essential responsibility. In most cases, solicitors must avoid holding client money personally unless specific regulatory conditions permit it. Referrals, introductions, and separate businesses. Transparency is key when solicitors refer clients to other businesses or accept referrals themselves. Clients must be informed about any financial or other interests that may be tied to these referrals. Fee-sharing arrangements must be clearly documented, and solicitors must ensure these arrangements comply with regulatory standards. When dealing with separate businesses, solicitors need to obtain informed consent from clients to avoid potential conflicts of interest. Conflict, confidentiality, and disclosure. Avoiding conflicts of interest is fundamental to maintaining professionalism. Solicitors should not act in situations where their interests conflict with those of their clients unless specific safeguards are in place and all parties have provided informed consent. Confidentiality is another critical obligation. Solicitors must keep client information secure and disclose it only when legally required or explicitly authorized by the client. Additionally, solicitors have a responsibility to ensure that clients are fully informed about material information relevant to their cases, except in situations where legal restrictions or other compelling reasons prevent disclosure. Cooperation and accountability. Accountability is an integral part of legal practice. Solicitors must adhere to all relevant legal and regulatory requirements and be prepared to justify their decisions and actions. They are expected to cooperate fully with the SRA and other oversight bodies, providing accurate and timely information when requested. Reporting serious breaches of regulatory arrangements is a professional duty, and solicitors must act honestly and transparently when issues arise. If mistakes are made, they must take remedial action, communicate openly with clients, and ensure that any harm caused is addressed promptly and effectively. Providing services to the public or a section of the public. When providing services to the public, solicitors take on additional responsibilities. They must clearly identify who they are acting for in each matter and ensure that an effective complaints handling process is in place. Clients should be informed about their rights to escalate complaints to the legal ombudsman if their concerns are not resolved satisfactorily. Transparency regarding fees, service details, and the regulatory protections available is essential to help clients make informed decisions about their legal matters. Client information and publicity. Effective communication is a cornerstone of good legal practice. Solicitors must present information in a way that is clear and accessible to clients, enabling them to make informed decisions. They are also required to provide accurate information about fees and services, ensuring that no aspect of their publicity is misleading. Additionally, solicitors must clarify which activities are regulated and explain the protections available to clients under these regulations. Supplemental notes and updates. The SRA Code of Conduct is a dynamic document that evolves to reflect changes in law and practice. Solicitors have a professional obligation to stay informed about updates to ensure they remain compliant with the latest standards and expectations. Closing remarks. Today, we have taken an in-depth look at the SRA Code of Conduct, examining its principles and the responsibilities it places on solicitors. This code is more than a set of rules. It represents a commitment to public trust and professional integrity. For those preparing for the SQE, understanding these standards is vital not only for examination success, but also for building a fulfilling legal career. Thank you for joining this podcast. And remember, ethical practice is the foundation of a trusted legal profession. Have a look around Dr. Yanis's channel for more SQE-related content.